All right, well, welcome everyone. This is episode 71 of Women on Wealth, and the topic today is the top estate planning mistakes and how to avoid them. And I'm going to say this up front. I know this sounds like a very overwhelming conversation. I have a lot of times people tell me, "Oh, that's not for me. I don't have the right assets." And I will say everyone needs to listen to this topic. And I think that my guest today will agree with me. Hi, Stephen.
Hi, Julina.
Nice to see you. So let me quickly introduce you. So Stephen Napier is a member of Berkowitz, Trager and Trager here in Connecticut. He is chair of the firm's trust and estate department. He practices in the areas of tax and estate planning, trust and estate administration, and business succession planning. He regularly advises individuals, families, business owners on the development of tax efficient, practical wealth management strategies, lifetime wealth transfer planning, and business succession planning. This includes preparation of wills, revocable living trusts, irrevocable trusts. Just to begin with, he is a frequent speaker on various estate planning and estate administration topics, and I think that's because you help simplify some of the complexities that we just went through. He is also a member of the Society of Trust and Estate Practitioners, which is known as STEP, which is the leading worldwide professional body for practitioners in the fields of trust, estate, and related issues. And then finally, he is a new dad to a 10-week-old girl. Is that correct?
That is correct.
You are here. You're not asleep. So awesome.
Exactly.
So with all that said, I know there's a lot of information here. And as I mentioned, you and I were just talking about this. This is an overwhelming topic, and I don't think we talk about it enough. So I love the fact that you have this sort of list. I know you're not going to go through all of it as in depth as you maybe would like, since it can get pretty dense.
Yeah, and so thank you for having me on the podcast. And look, the goal, and the same with when I talk with clients about this stuff, the goal is to simplify it to a point where it's understandable, right? Because if it's not understandable, how can a client make an informed decision, right? And so
Yes.
even with this list that we're going to go through, it's just sort of like for the average person, what are some of the considerations that are important, really for everyone?
Yes.
And how can
Exactly.
they be addressed? And some of them aren't too difficult to address. You just got to kind of make the decisions and walk through it. And so, you know, really the main one is the obvious, right? Not having an estate plan at all, right?
Yes.
You
Which
know,
we
and
find all the time, right? All demographics, all levels of net worth. It's amazing. And I
yeah.
think, as you and I said, it's actually sometimes just the impetus of getting it done.
Yes, and I've had clients come to me that have extreme levels of wealth and no estate plan. So, it really does vary. And I think one of the big problems, and this is particularly for married couples, is there's a feeling of, well, we're married, we have kids. If I were to pass away, my assets will just go to my wife, right? And
Yes.
that's sort of an assumption, right? But actually, that's not the case. There are assets that are held jointly with right of survivorship. When one spouse dies, yeah, that'll go directly to the spouse. If you have an asset like a retirement account that has a beneficiary designation and you've named your husband or wife, yes, that will go directly to them. But for the assets that are in your individual name, state law is actually going to govern where they go. And so I can just give you an example for Connecticut. If I die in Connecticut with no will, the assets that are in my name will pass. The first $100,000 will go to my wife, and then the balance will go 50% to my wife and 50% to my kids. And that includes bank accounts in my sole name, real estate in my sole name, private investments, stocks, even deferred compensation, if there's no beneficiary designation, can fall into that category. And so,
Right.
very quickly, what happens is, just I can use my own example. I have life insurance too. And so like some of these assets, they're larger than you may think. And before you know it, 50% is going to my, 2-year-old and 10-week-old, right?
Yeah.
And so you might say, okay, that's fine. Well, my wife can manage that for them. That's not how it works in Connecticut or New York or any other state, because the state has an interest to make sure that a beneficiary, if a person who dies has not expressed their wishes,
Yes.
that the state is protecting those wishes. And so what happens is the probate court requires that those assets for a minor child end up in a guardian account. And they're called restricted guardian accounts that essentially are administered by the probate court. And so, in my example, if my wife says, okay, I need $1,000 out of that account to pay for, my son's camp,
Yeah.
she has to go to the probate court, apply for it. It's $250 every time you do this. The court has to actually issue an order saying, yes, you can remove $1,000 from this account to pay for that. She then has to take the order to the bank where that account is. The bank then releases the funds. You have to do that every single time you want to take assets out of that account for a minor child. You have to file accountings every year. It's very cumbersome. And then, one of the even bigger potential problems is when the child reaches the age of majority, let's say they're 18 or 21, depending on what state it is,
Yeah.
they just get the money, right?
Exactly.
And if it's a significant amount of money, that's problematic too. And so
whether they're ready for it or not.
right, whether they're ready for it or not.
Yeah.
So, that's one of the things that for any couple that has children, that's a significant consideration. And the rules are different for different scenarios. If you die with a spouse but no kids, a piece of that goes to your parents. If you die with a spouse and kids from a prior marriage, it's just 50-50, 50% to your wife, 50 or husband, 50% to your kids. So,
Wow.
the money doesn't go to the state. Some people worry about that, but the state law will basically determine where it goes.
You're allowing the state to make the decision without knowing the family dynamics.
Correctly, and also, the form of how it passes, right?
Yeah,
So
fair.
it's a cumbersome process. It doesn't allow you to do any planning, right? Typically, and we'll talk about some of this later, but typically, with minor children, you want to at least have a trust that goes to a certain age, right?
Yeah.
Maybe it's not 21, maybe it's 25 or 30 or age 35, and at least give a little bit of a longer runway for someone else to make decisions on those funds for the benefit of the child until it's appropriate for them to do so. And what age that is varies on the client, it varies on the child, it varies on the dollar amount, right?
Yeah.
If it's $100,000 going in the trust versus $50 million, you're going to think about those ages and sort of a child's ability to manage those funds a little bit differently. So,
Yeah.
the key thing about not having an estate plan is you really have no control over where assets go. Aside from that, you don't have any control over who controls the estate. And I'll give you a few examples, who
Please.
is executor of the estate, right? So, if I die without a will, yeah, my wife would probably end up being the administrator. So when there's no will, the court appoints an administrator, but the court is going to decide, right? And maybe in my scenario, it's straightforward. But if I was single, right, maybe I have a family situation that the dynamic isn't straightforward. Maybe, my parents are estranged from a sibling and the sibling wants to be executor and my dad wants to be executor. And so like, if you haven't sorted that out, the court's going to decide who the executor is.
And I think, Stephen, to your point just now, that these circumstances that you're talking about, that almost seems like the norm of any family today. There's always some type of dynamic going on within the family, and the courts are obviously not going to understand that.
No, and they're going to have to sort through it, which will be painful for your family members when someone dies unexpectedly, right? They're already dealing with the grieving process. Now they're dealing with hiring attorneys to fight over, executors and trustees. But really the bigger one, which I haven't presented yet and is, I think most worrisome to young couples is guardian for a minor child, right?
Yeah.
In my case, right, if something happens to my wife and I, right, who becomes guardian for our minor children? Is it my brother? Is it my sister? Is it my wife's brother? Is it my parents? Is it my wife's parents, right?
Yeah.
And so, inevitably the court decides on guardianship, even when you do have a will, but they're always going to defer to the wishes of the individuals unless there's a clear reason not to, right? Like, the person you've named is in prison, right? Or they're in the military and they're at sea, right? There's circumstances where the court just simply can't, green light that choice.
Yeah.
But other than that, they're going to pick who you want, and that will prevent, a fight amongst family members over who should be guardian. And frankly, those fights oftentimes are well-meaning, right? My parents don't know what my wishes were, and my wife's parents don't know what her wishes are because we haven't said so, and so they may have different opinions on what's best. And so
Yeah.
it really is important that you lay those wishes out, so the court knows what to do, and it's clear, and that just avoids some of the messier situations that can happen
Yeah.
after death.
It's all of these circumstances are making me cringe when I remind myself on how many people are telling me, oh, I haven't gotten to my will yet. I'll get to that, which we hear all the time. People keep pushing it
Yeah.
away. And so thank you for making that feel more real. So I know another one too, and again, this comes up a lot. Oh, that doesn't really refer to me, but it may even more so going forward. Can you talk about the estate tax?
Yeah, so there is a federal estate tax and there is a Connecticut estate tax. And for clients in New York, there's a New York estate tax. Now, the good news is the exemptions, both federally and Connecticut, are the highest they've ever been. So right now, the estate tax exemption is 13.6 million each. So about 27 million combined that a married couple can shelter from estate tax.
Right.
The federal estate tax rate is 40%. The Connecticut estate tax rate is 12%. And so for most couples now in Connecticut, estate taxes are not the primary driver of an estate plan. Tax planning doesn't need to be the primary driver. However, you still need to consider that and do some level of tax planning in the documents because these numbers aren't static. They continue to change. And, the Tax Cuts and Job Act, which went into effect in 2016, that's going to expire at the end of 2025. When that happens, I should say, if that happens, those exemptions are going to get cut in half. And so essentially it'll be 7 million each. Now, it wasn't that long ago, 6-7 years ago, the federal estate tax exemption was $5 million and the Connecticut estate tax exemption per spouse was $2 million. And look, there have been proposals in Congress, in the last couple of years to return the exemptions back to 5 million, 3.5 million, right? And so what we want to do is plan in a flexible manner, right? We don't want to overcomplicate an estate plan, add tax planning we don't need. But at the same token, I also don't want to do an estate plan for a client and then, the presidency and Congress, who's in power shifts in 2024, and I have to call them in a year and say, hey, we need to redo that whole plan
Exactly.
right away, right? So
Yeah.
the tax planning should be in it because these numbers will continue to shift. Unfortunately, just the way things are in Congress, it's a political football that's going to keep bouncing around depending on who's in power.
Yeah, absolutely.
The other thing I want to mention as far as those exemptions, two things really. One, if you don't have tax planning in the document, like let's say you have a simple will that says on my death, I just leave assets outright to my spouse. That's fine. There shouldn't be any estate tax if your spouse is a U.S. citizen. However, by doing that, you lose the exemption of the first spouse when at their death. So essentially, I have a $13 million exemption. My wife has a $13 million exemption. But if I just leave assets outright to my wife, my $13 million exemption is gone. And so at her death, she'll just have whatever her Connecticut estate tax exemption is. More of a Connecticut issue than a federal issue right now. But look, that may not be an issue right now, but if the exemption drops to 5 million or 2 million, it can become more of an issue. And the second piece of this, and I always have this conversation with younger couples where they say, we don't really have that much. We've got a house, we've got a few bank accounts and, some retirement and that's sort of it. But, then you start talking, well, do you have life insurance? And it's like, okay, I have a $2 million policy. My wife has a $2 million policy. Oh, I have life insurance through work. For two young spouses to die at the same time young, oftentimes there's a liability situation, right? Maybe, it was an accident and there's a lawsuit associated with that accident that could net $10 million, $20 million. I mean, they can be very significant when they're young individuals who die unexpectedly. And so, it may be a client who looks at their balance sheet and says, we really only have a few $100,000 or $1 million. But when you start adding in life insurance and you start considering potential liability, because if this is relevant, it means you've died unexpectedly, suddenly that estate could be 10 or 20 million very quickly. And the tax planning, the trust planning for kids, some of that stuff very quickly becomes relevant and important when it didn't feel like it would be.
Absolutely.
Right.
Yeah.
And so all of this is sort of planning for the unexpected. And in the unexpected, things are going to happen that are out of the ordinary. And so you've got to take that into account when you're thinking about the estate plan.
Yeah. And I'm also thinking of it from the standpoint, it's hard enough to get people to plan. So to get them to come back and review the plan, let's say even every 10 years is sometimes a challenge. I mean, time goes by very quickly. Assets can accumulate very quickly, especially if you're in a good market. So I think just having the plan, even if you don't think you necessarily need it just yet, is it fair to think of it that way?
Yeah, absolutely. Right. You get it established. And I have this conversation with clients who are having particular trouble making certain decisions. Guardian is one of them, right? They just can't come to an agreement on it, or, sort of how things are structured for kids. Another scenario where this comes up even more often is sort of second marriage, stepchildren scenarios where it's a very difficult discussion of, hey, if I die, what do I leave to my current wife versus my current children versus my children from a prior marriage?
Yeah.
And oftentimes what happens with those clients is they don't do any plan, right? Because they and maybe their new spouse just don't see eye to eye on that. And it creates, angst and disagreement. And, that's the type of client that's needs a plan the most, right?
Exactly. Yeah.
Because those little decisions can significantly shift, not just the flow of assets and where they go on death, but kind of the power dynamic, right? What's going to kids from prior marriages and current marriages. And a lot of times those situations are harmonious because the person's still alive, sort of bringing everyone together, right? But once they're out of the picture, well, now it's just, children worried about their inheritance and a stepmom, and she's worried about her living expenses, and it creates a different dynamic. So to your point, those are circumstances where very important, but also, staying up to date with an estate plan. What I always tell clients is, look, let's try to get this as close to perfect as possible, but keep in mind, you can always change it. Things are going to change. You're going to make decisions for your children when they're 5 years old that when they're 20 may not look the same, right? I oftentimes have clients that they set up trusts for their kids where, their child gets half at 25, half at 30. And, they come back when they've got like a 19-year-old in college and suddenly they're like, okay, 25 seems a little close. And, my maniac child running around college isn't really ready to manage that kind of wealth. And so you make changes in that.
Yeah, I think that's important.
Another component is yes, your own personal circumstances, right? Your assets may increase or maybe even decrease significantly, right? In which cases maybe there's complexity in the plan that doesn't need to be in there, and that can be taken out of it. And then personal circumstances, right? Children that get married, children who are married and maybe have a shaky marriage, or they've got children that have special needs, and how do we incorporate that into the plan? Asset protection concerns, right? Do you have a child who's a practicing surgeon now? Well, then there's different creditor risk concerns that child would have and can be sort of addressed in the estate plan that maybe weren't relevant when the child was 15. Every 5 years or so, absent there being some significant change, every 5 years. So, give me a call. Let's talk about what's going on. And, most likely the documents don't need to be updated. But if they do, we can talk about what needs to change.
Absolutely. And I love that because sometimes it's nice to hear from an outsider looking in, have you addressed this situation? And it's not just maybe the legality that's changed, but also just the circumstances within the family that maybe some people just don't want to admit to.
Yeah, and people and what they do, right? Roles, guardian. It's a perfect example. Like, you name your sister as guardian, but maybe she moved, right? Maybe she took a new job and she lives in London now, is married with her family, and that may not be appropriate anymore. So those sorts of changes also can necessitate changes to who you've appointed as executors, trustees, guardians. In the plan.
A lot can change over 17 years as a child is growing up.
So I hear.
Yeah. So another big one is not planning for probate.
Yeah. And so, one of the things the estate plan does is, we talked about the court picking executors and all
Yes.
of that. And so the plan will streamline the probate process. But one of the things people often want to do is avoid probate. And what I would say to Connecticut clients, what I do say to Connecticut clients, the good news is most courts in Connecticut, most probate courts are actually relatively efficient. You can get executors appointed relatively quickly. They're user friendly.
Okay.
You can call the court and speak to the chief clerk and ask a question about a quirky situation, and they can talk to the judge and sort of guide you. Hey, this is what you should do. And so we find the court helpful
Good
and
to
pretty
know.
efficient.
Yeah.
I can tell you that that is not typically the case in New York.
Okay.
It can often not be the case in Florida. It's certainly not the case in California, where, aside from the court being a little less user friendly, they charge significant fees based on what assets actually are probate assets versus which are not.
Oh, wow. Okay.
But aside from sort of the user friendliness of the Connecticut courts, like what a lot of people often want to do is just avoid having to deal with the court, avoid having to
Yeah.
file the will at all. And so, for many estate plans, I'd say for most estate plans, we use revocable living trusts, and they're essentially will substitutes. And what you can do is during your lifetime, you can actually fund the revocable trust. So, for example, if I have a bank account in my name, I can retitle it into the name of my revocable trust.
Right.
Completely disregarded for income tax purposes. It doesn't change anything. I control it. But upon my death, that asset doesn't have to sort of flow through the will into the trust. It's already there.
Right.
And if I do that with all of my assets, well, then I don't need to file the will at all.
Interesting.
And
Yeah.
so it avoids some of that administrative burden after death. Another benefit of a revocable trust, aside from avoiding probate, is also avoiding the visibility of probate. And what I often tell clients is, look, when you establish a will, it's private. No one can see that will until you die. Once you die, we have to file that will at the probate court.
Yes.
It goes in the probate file, meaning anyone can walk into the court. Now, will they do this? Some will, some may not, but anyone can walk into the court and just say, hey, can I see the Smith estate file, and open it up and read the will. And as part of that, if you have everything in that will, it'll say, when your husband or wife actually gets assets and what they get. It'll say your children, how are they getting assets? What ages are they getting assets, right? You don't really want that public. And so,
and maybe there's a family dynamic that you don't want public.
correct. Yeah. You may not want, nosy neighbors, cousins, estranged family members from seeing who's getting what and how. And so by using a revocable trust, the revocable trust remains private. You'll file a will that just says, upon my death, I leave assets to my revocable trust.
Right.
That doesn't tell anyone anything.
Okay.
And then the trust actually has all the nuts and bolts of who gets what and how and who's trustee. And so, as part of this sort of probate piece of things, revocable trusts are really effective at avoiding not just the mechanical administrative hassles of probate, but the visibility of probate.
Okay.
And so we like to rely on them a lot. They also can potentially avoid Connecticut state income tax if you have trusts set up in a revocable trust as opposed to trusts set up in a Connecticut will.
Got it.
So there's a lot of benefits of why we use revocable trusts, and not just wills, but it all sort of falls into this bucket of how do we plan to make the probate process as minimally invasive and also time consuming and stressful for the client, because that period of time when someone passes away, and it's oftentimes unexpected, is a very difficult period of time. And the last thing you want is to be dealing with, court issues and hearings and all of that.
Yeah. And I think the revocable trust is a very popular option, given everything you just said. I think it's also fair. It's also fair to point out, right, Stephen, that it is still in your estate because it's a revocable trust, right? It's not out of your estate. Okay.
Correct.
Yeah.
It will still be treated the same way as if the asset is in your name.
Yeah.
There are some tax benefits you get when you die. The assets get stepped up in basis. Essentially what that means is if there are, embedded capital gains in your bank accounts, your real
Yeah.
estate, you don't lose that benefit by funding a revocable trust or having a revocable trust.
Yes. Great point.
So they're really effective vehicles we use. And the key thing is they're revocable. And so that means you can revoke it, you can amend it, you can change it at any time. And
Yeah.
so much like a will, it will change over time and evolve essentially with as your financial life evolves and as your family
Yeah. That's
evolves.
great. No, thank you. That's an important one. So I love that you went through that. And what about, I know this is a big one for you. You talk a lot about choosing the wrong executors and trustees.
Yeah, and this, to your point earlier, every family is different, right? Every family has different, or I should say, individuals of the family have different strong points and negative points. Like, you've got a sibling that's brilliant and has a great financial mind, but they're a workaholic and they work 80 hours a week and they live in California. Or you've got someone who's a great caregiver, but they're really financial matters is not their cup of tea, right? And
Or
so
yeah.
when we're thinking through, who should be an executor, who should be a trustee, who should be a guardian, we got to work with who you have, right? In some families, they've got the right person for all three of those roles. In a lot of cases, it's the same person for all three of those roles. And I'll talk a little bit quickly about what each of those roles exactly is. But other families, that's a different person. And for some families, they really don't have the right person. And I'll explain that. And so, kind of what is executor? What is a trustee, right? And so the way I would describe this is, upon, let's say, if I were to pass away, right? My executor is the person who's going to administer the estate. And so what they're going to do is, pay any debts and expenses of my estate, figure out what are my assets, what do I actually have.
Yeah.
They're going to file probate documents, actually file the will for probate, get an executor appointed. They're going to file a Connecticut estate tax return, which is required for every estate in Connecticut,
Okay.
whether it's taxable or not. And then, basically enforce the wishes of the will. And in my case, it would be move these assets to my revocable trust, right? And so that's about a year-long process. And once that process is done, it takes time. And once that process is done, the assets are in the trust. And that trust may say, let's say I'm not married and I have kids, right? So that trust would say, okay, leave these assets in trust for my two kids until they're 35. Now there's a trust for each of my children, right? And the trustee is the person who manages that trust. They've got three main roles. Sort of the obvious role is, my child is 21 and says, hey, I need a new car, right? Well, what does that mean? Does that mean a Toyota? Does that mean an Audi? Does that mean a Ferrari? The trustee is going to make those decisions and certainly pay for educational expenses and living expenses, but in their discretion, right? Maybe my child doesn't need to be living in a penthouse in New York City when they're 20 years old. And so that's the main point, the main role of being a trustee. And that sort of spans the length of the trust. So that can be a much lengthier role than the executor role, which is shorter term.
Absolutely. Yeah.
The second part of it is, making sure the assets are invested appropriately, making sure that any administrative requirements are being met, that tax returns are being filed. And so, when you're thinking through this, like that, the judgments and responsibilities of the person that's going to be the trustee, which can span a longer period of time, may be different than executor, right? Because executor is a shorter period of time, but that's also more of like an on the ground role. And what I mean by that is if something happened to my wife and I, our executor or my executor has to deal with my house, right? What happens to my house? If my kids are going to live with, one of our siblings, well, then the house has to be cleaned out and this has to be sold. And so there's a little more of that kind of like day-to-day activity in an executor that might be difficult from a distance. So with different clients, there's different people that their skill sets and their circumstances will sort of guide them to be one role or the other, or maybe both.
Yes.
Guardian is really more of a custodial role. Who does your minor child live with?
Yeah.
Who signs off on, school trips and things like that, right? And so
Yeah.
maybe that's the same person as the trustee. Maybe it's
Okay.
not. This is kind of the lay of the land that we try to manage with clients. And, for some it's an easy conversation and they know who to pick. For some it's very difficult. And so every family is different. The people are different, the circumstances are different. And my job is to try to listen and just kind of guide them through that selection process.
Well, and I was just thinking it must happen all the time for you where someone comes in and they perceive to know who the executor or the trustee would be. And as you start to guide them through the scenarios and the questions, you must sometimes have them think, you know what, that actually, maybe that's not the best person for me in that situation.
Yeah. Oh, that happens a lot, right?
Yeah.
I consider the meetings I have with clients to be more educational,
Yeah.
playing devil's advocate. But the goal is to make sure that the decisions are fully informed. But at the end of the day, it's the client's decision. My job is to help guide them to the best decision they can make. And again, it's not always a perfect decision. And to that point too, we try to name backups in all these roles. Maybe sister in, wherever is the first choice, but that may not be the right choice in 3 or 5 or 10 years. And in fact, at that point, maybe that spouse or that sibling, let's say, can't do it.
Right.
And so you want to name a contingency plan just in case that doesn't work.
Yeah, I love that point. And another one that you have that is one of my favorites because I feel like I'm having this conversation all the time is not having a power of attorney and healthcare
Yes.
proxy. This is the big one for me.
Yeah, very important. And so, background on those documents, what do they do? A power of attorney is a document whereby you name someone to essentially make legal and financial decisions for you. This would be during your lifetime. If I were incapacitated, who would pay my bills? Who could access my bank account to pay my bills? Who could sign my tax return? If all of my accounts are joint with my wife, she can obviously still access those accounts by virtue of being an owner of the account.
Right.
But that isn't always the case with every married couple. Some married couples have assets that are separate. If a client isn't married at all, right, they're going to be the individual owner of all those assets.
Second marriage.
Yeah, second marriage. Who can actually deal with all of those issues? So critical to have that document and name, probably a primary and also secondary.
Yeah.
The healthcare proxy, is naming someone to make medical decisions for you. And again, only in the scenario that you could not yourself. And so, married couples usually name each other, but who would be backup, right? What if something happened to my wife and I was still alive, but I couldn't make medical decisions, right? Who would do that for me? And so for both of these documents, power of attorney, healthcare proxy, if you do not have them, then that role gets determined by the probate court. They're often called conservatorships, right? There have been very many high-profile conservatorships. Britney Spears was one of them, right?
Yes.
Where, a court has to step in and say, well, Stephen's brother wants to make medical decisions, but Stephen's father wants to make medical decisions. And so the court has to decide who's going to make medical decisions. The court also needs to decide who's going to have access to my bank accounts to pay my bills if I'm not capable of doing it myself. And so you sort of prevent that issue by designating who these people are in your own documents.
Okay.
A connected piece to this, and I know this is probably something that comes up with your clients as well, is children that are no longer minors. Right now my kids are 2 and 10 weeks, right? I can go to the pediatrician and they'll release any information to me because I'm their parent. But the moment my son turns 18, if I call the pediatrician and ask for information, they're not going to release it to me without authority to do so. And this comes up and worries a lot of parents, particularly when their children go to college. If something happens to their child in college and they call the health center or infirmary and say, what's going on, unless the child has signed a document authorizing the release of information, they can't access that information. So the healthcare proxy isn't only an authorization to make medical decisions, it's also an authorization to release information, a HIPAA authorization. And so oftentimes for clients, once their children have reached age 18, we'll do powers of attorney and healthcare proxies for, their young adult children, just so there's that free flow of information with the school or doctor or whomever.
And I think this comes up a lot with parents that have children, adult children that maybe have mental health issues, drug abuse.
Yes.
That's come up a lot too. And so I think this is an important point, that to have access to that information.
Yeah, very important.
And Stephen, how do you answer the question if someone comes to you and say, "Oh, I have a power of attorney, I don't need a healthcare proxy"? That comes up a
Yeah,
lot.
well, yeah, right. And the power of attorney is only dealing with one piece of this. The healthcare proxy deals with a different piece of it.
Yeah.
And so you really do want to have both of those documents.
Okay. Thank you.
A related issue that comes up is out of date documents. And I can tell you, powers of attorney and healthcare proxies do not expire.
Okay.
As a matter of law, they do not expire. But what you run into a lot of times with banks is they're very concerned about their own liability or, power of attorneys being abused. Frankly, powers of attorney are often abused.
Yeah.
A lot of times it's elder abuse, right? Where an elderly parent has a child as sort of like caretaking for them, and they're the power of attorney, and they're taking assets out of bank accounts and using them for purposes that really aren't what they should be using them for. And invariably what can happen is the bank can get sued. Here's a scenario, right? Parent executes power of attorney naming child. Parent gives child copy of that power of attorney. 5 years later, parent signs a new power of attorney revoking that one, naming a new child, or let's say another child, right?
Yeah.
If the child shows up with that, the prior child shows up with that older revoked power of attorney at the bank, how do they know that power of attorney has been revoked, right?
Exactly. Yeah.
And so what ends up happening, what I've seen happen is, parent signs power of attorney, it's dated, 2013, and child tries to use it, and bank says, "Oh, no, this is 10 years old. We need a signed document from the parent saying this is still in effect, or we need to see the parent in here authorizing it." Well,
Wow.
oftentimes, if the power of attorney is being used, it's being used because the parent isn't capable of doing that, right? They have dementia or Alzheimer's, or they're actually in a coma or something like that, right? Where and I've had this happen with banks, and I say to them, this power of attorney does not expire. You actually cannot deny accepting it, but they put roadblocks, and it can be a multi-month process finally getting them to accept it. And so, to your point, keeping these documents up to date is important. And they don't expire, but you don't want to run into those issues with a bank.
Can create a hell of a lot of hassle. So let's say with a power of attorney, what do you recommend? 5 years? Is 10 years too long?
Yeah, I mean, it depends. Realistically, for a young client, the odds of an incapacity sort of arising unexpectedly that's lengthy, it doesn't often happen, right? Sort of catastrophic situations with young clients often result in death or a short period of incapacity.
Yeah.
So maybe for a younger client, every 5 to 7, 10 years, sort of revisit those. But for elderly clients, clients that are already in their 70s, 80s, already have sort of capacity issues, maybe sort of early onset Alzheimer's or dementia, or these are becoming more relevant.
Sure.
They should probably update them every 2 to 3 years, I would say.
Okay.
And
Wow.
it's an easy thing to do, right? You could essentially re-execute the same document. You just need to execute it in front of witnesses and a notary. And so I think it's a little bit of case-by-case basis, but you certainly don't want a 20-year-old power of attorney with a 75-year-old client, because that's going to be a very cumbersome process to use that power of attorney if you need to.
Yeah. I mean, again, these are just circumstances that you don't really think about, but you can see them coming up. So thank you. And what about tax planning?
Yeah, so we talked a little bit about estate tax planning, but there's also an income tax planning piece to estate planning. Right now, given the higher exemptions, there are estate plans floating out there that have more complexity in them than they need. I'll just give you an example. I have clients that regularly come to me that they did an estate plan in, let's say, 2003. Rewinding to 2003, the federal estate tax exemption was very low. It may have been 1 or 2 million, 675,000. It was somewhere in that ballpark. I don't remember off the top of my head.
Yeah.
In Connecticut, the Connecticut estate tax sort of changed forms in 2005, but it was also very low. It was, $1 or $2 million. And so if a client came in with a $3 million net worth in 2003 or 2004, they're going to have an estate plan that has trust planning that is mandatory. And what I mean by that is, on the first death, assets pass in trust with the surviving spouse, and there may be a mandatory co-trustee with the surviving spouse, because the tax laws were a little bit different as far as, can a spouse be sole trustee of a trust for their primary benefit? And so fast forward now to 2024, and let's say that client's net worth is now 4 or 5 million. Well, they now have a plan that might be the way I plan for a client who's worth 25 million. You might say, well, what's the downside of that plan? Well, the first downside is it has complexity it doesn't need, right? When the first spouse dies, there are trusts that are mandatory for the survivor. Those trusts have tax returns every year, and there may be a mandatory co-trustee, so you have to have someone else involved. And there's sort of an administrative burden to those trusts that, hey, maybe we don't want that. We didn't need that. So, with clients, if I say to them, hey, we can do this in a more simplistic manner, that's always a welcome change. You don't want complexity you don't need. The second piece of it, I talked a little earlier about the step up in basis on death. You get a step up in basis on death of assets that are in your name, but not necessarily assets in trust for your benefit. So I'll just give you a quick scenario. Let's say I own, a share of Apple stock. Let's just say it's worth $100 today. I bought it for $1. If I sell it today, I have a $99 capital gain. Let's say that's taxed at 20%, right? If I die today and my executor sells it tomorrow, well, instead of the basis being $1, the basis becomes $100. So if my executor sells it at $100, there's no capital gain. And that's called the step up in basis. So all of your assets get stepped up in basis on death. So let's carry this out. That asset, let's say my estate plan just leaves the assets outright to my wife. My wife now gets that stock with a $100 basis. Let's say that stock rises to $200. She dies. The basis on her death goes from 100 to 200.
Right.
And so if her executor sells it for $200, there's still no capital gain.
Yeah.
Now let's go to the scenario of that client I mentioned. So let's say I die, the asset goes into a trust for my wife. When my wife dies, that trust is exempt from estate tax. But in this scenario, there wouldn't be an estate tax because our assets are less than the exemption. The problem is that trust for my wife's benefit does not get a step up in basis on her death because she doesn't own that asset. The trust owns it. And so instead of that, in my example, instead of that Apple stock, the basis going from $100 to $200, the value on my wife's date of death, it stays at $100.
Right.
And so, my kids inherit that stock with a value of $200 with a basis of $100. If they sell that stock for $200, there's a 20% capital gain or 15% on that $100. And so, I sort of went through a little quickly, but the long and short of it is there can actually be an income tax downside to having some of this more complex estate tax planning for clients that they have plans that are out of date and we're in a different world. What is more of a threat to each individual client? Is it estate taxes? Is it income taxes? And so a lot of the decisions about the structure of the estate plan is governed by those considerations. A last piece I'll mention to this is sort of forward looking where the assets are going in the client's life, right? Maybe the state estate tax is the main threat. In some states like New York, the exemption is only 6.5 million.
Right.
It's less. But if that client is going to move to Florida and the surviving spouse is going to die in Florida, well, maybe some of this planning around estate tax at the death of the surviving spouse, we don't need to worry about Connecticut or New York estate tax because they're leaving. And so that's a piece to the estate versus income tax planning as well. All of that is sort of forward-looking considerations when we're thinking income taxes, estate taxes. How does the plan need to be set up?
Yeah, and I love your comment about forward looking, because I can't tell you how many times people don't understand the step up in basis until after the fact. And they're like, oh,
Right.
I wish I'd known there was a more efficient way to do this, because to your point, it depends on where it is and what the situation is. And the other thing I guess I would mention, we are in an election year. And
Right.
this came up 4 years ago in the previous election as to whether or not these laws were going to change. And that was a big deal. And so, as confusing as it is, it can completely change on us too. And let's flip and talk about one that seems so simple, and yet it's amazing how often it can get ignored. Let's talk about designated beneficiaries and ownership.
Yeah, that's a big one, and one that gets messed up a lot, right?
Yeah.
And oftentimes not even for the individual's fault at all. Like I can't tell you how often I've had a client that they updated their beneficiary designation for an IRA or 401k, and for whatever reason the custodian lost it, or the custodian changed. Sometimes this happens
Wow.
with life insurance policies,
Yeah.
and it just kind of disappears, right?
Wow.
And they don't update it. And so, you've got situations where a client thinks they've named their spouse or their children, but they've still named their mother, or they've named their sibling, or they've named their ex-spouse. For some of these, it would automatically change at the divorce, but some don't.
Yeah.
So the first thing is making sure they're correct, right? And I always one of the first things I say to clients is, look, hold the beneficiary designations on all of your retirement accounts and life insurance, and make sure they are what you think they are. And I cannot tell you how often it's simple, but sometimes it's annoying, right? You've got to log in, and your login doesn't work, and it says you've got to call an 800 number. And so these are some of the annoyances, but it's really important because, for a lot of clients, beneficiary designation assets are the bulk of the asset.
Yep. I love that point.
Them doing what you want them to do is another big issue that we talk about, because you can set up an estate plan that is, in a revocable trust that's wonderful and does exactly what you want. But if the assets don't actually flow through the plan, then what did you accomplish?
What's the point? Yeah.
Yeah. And so, like, a perfect example of this, I set up a plan that says, all right, the assets go to my wife. If my wife doesn't survive me, they go into a trust for my kids till age 40, right?
Common.
Well, let's say on my life insurance policy, I name my wife as primary beneficiary, and contingent, I just check the box, lineal descendants per stirpes, means equal shares to my kids. Or maybe I just name my 2 kids.
Yep.
If something happens to my wife and I, that's going to go to my kids directly, because that's what the beneficiary designation says. It doesn't automatically flow through my revocable trust just because I have one.
Yeah.
You have to designate the asset to flow through the revocable trust. And so for both life insurance policies and retirement accounts specifically, you want to make sure that the contingent beneficiaries, especially when you have minor children, that the contingent beneficiaries actually flow through your estate plan. Okay. Right? Because back to what we talked about, guardians and the probate court, even if you set up a will or in a revocable trust that sets up a trust for your kids until they're, 30 or 40, if you didn't update your life insurance beneficiary, and you've got a $2 million life insurance policy, and your wife or your husband and you both die, the $2 million, what's going to happen is the custodian is going to say, these are minor children. We cannot release that money unless there is a guardian account set up, and you have to go to the probate court, and the court will require you to go through that whole process with the guardian account and everything else, because the beneficiary designation went directly to the kids, not to the trust for them. And so that is a really important step that oftentimes gets missed, and is really important to make sure you follow through on updating the beneficiary designations, when the plan is set up.
And you want to make sure they're not contradicting each other.
Yeah.
I think your comments, it's one of the reasons that some of these financial planning tools that are out there today that firms like mine can use have this focus now on estate planning and showing the flow and being able to map out for a client like what it actually looks like overall, right?
Yeah, and I can say sort of from my perspective as the estate planning attorney, having someone like you involved is enormously important. And the main reason is, client comes to me, we set up their estate planning documents. I have my eyes on sort of what assets are and beneficiary designations, but oftentimes there's a gap in time where I don't hear from or speak to that client for 5 years, 10 years, sometimes even longer, right?
Right,
Some
fair.
clients I'm working with on almost a weekly basis, but others, there are large gaps in time. And
It's
so,
probably most of them.
yeah. And so,
Okay.
that's why aside from just, investing the assets, having someone like you involved to sort of keep your eyes on, hey, these life insurance policies, how are premiums getting paid? And,
Yeah.
what are the beneficiaries set on your new IRA or the 401k for your new employer? What
Yeah.
are your benefits at your new employer, right? Having someone who more regularly has eyes on those things, right? Because you
Yeah.
probably talk with clients quarterly or, at least several times a year.
Yeah.
You are there to make sure these things don't slip through the cracks. And so
Yeah.
for me, that's enormously valuable for the client.
Yeah, and we say this all the time to our clients. We want to be part of that team that they build and making sure that
Yep.
the team is interacting and working together so that it provides them a better outcome. That's all.
Yeah, absolutely.
So, thank you for that. This was a ton of information, but I'm hoping that if every listener gets a nugget or two from it, this helps us move forward. So thank you again.
You're very welcome. And again, like don't get overwhelmed by all these different pieces. At the end of the day, the first call, right? Like I don't have an estate plan. What do I do? Like
Yes.
that's the step. And then it's my job and your job, right? It's our job to quarterback and guide that in the directions it needs to go.
Yeah.
We won't need to talk about every single one of these issues with every single client. I don't want anyone to feel like this is sort of an overwhelming topic.
Yeah. No, I love that. It's please make that first step so we can help guide you going forward.
Exactly.
Yeah. Thank you.
You're very welcome.